A new Supreme Court term begins today following a summer-long recess, but it was hardly a vacation as justices handled one emergency request after another. The court is scheduled to review 39 argued cases, which include a pair of cases challenging transgender student-athlete bans, a death penalty case, and how multiple IQ scores factor into whether a person is eligible for the death penalty, and arguments involving a pregnancy center in New Jersey challenging a state investigation alleging it misled people into thinking its services included referrals for abortion. Tomorrow, the court will hear bans on therapy aimed at changing sexual orientation. Currently, almost half of U.S. states have passed bans limiting this type of therapy. Walter Olson is a senior fellow at the Cato Institute at the Robert A. Levy Center for Constitutional Studies. He joins us now. Walter, with the court more conservative, do you think the gender identity bans will be upheld?
I think there's a good chance that the transgender advocates are going to lose on the two cases before us, and starting with the conversion therapy one, which is going to be argued tomorrow at the court. Colorado enacted one of these laws, and it is being sued by a therapist who points out that this is restricting her speech. It's also restricting her client's speech. She would like to explore areas in conversation. She's a talk therapist, not a drug-giving therapist, and she says this is limiting her speech in a way that the First Amendment very clearly does not prohibit. Now, Colorado takes the position this is conduct, not speech, and you're opening the door here. If you say that we can't regulate what doctors say, then perhaps we would have to allow them to engage in quackery and false advice to their patients. The court has been teeing up this issue for a while, and I think the votes are there probably to say no. This is not just conduct. There are issues here that the First Amendment does cover, and there's also an asymmetry here, because as the therapist points out, if she were urging her patients to be more transgender, as it were, the law would give her no problem at all. But if she instead diagnoses a particular patient, saying, no, that's the wrong direction for this patient, it's not the way they really should be winding up based on their own values, then the law steps in and silences her. So I think she's likely to win on one or both of those issues. Now, in the other case, it's athletes in high school and college. And the cases there from Idaho and West Virginia say that in those cases, the appeals courts have ruled illegal state laws in Idaho and West Virginia saying you've got to play on the team of your original sex of birth. In Idaho, the Ninth Circuit has ruled that the federal Constitution prohibits that under equal protection. In West Virginia, the Fourth Circuit ruled that it violates federal education law, federal discrimination law. Again, I think that the schools and the states are going to win on that and find those laws upheld, particularly Idaho, because there's no way this court is going to find a constitutional right. Reading federal discrimination law is always a little more a matter of what does the exact text say. Even so, I'd be surprised if the state lost.
Thanks for reviewing some of the details for those cases. Now, what does the number and type of cases that the court has taken say about this term to you?
They've taken fewer cases every year than the year before, typically, and that's also true this year. I think it's only in the 30s. But you mentioned when we started the emergency docket, and that's where the balance is changing. They take more and more cases that come up over the course of the year that may not be final, where they are deciding on a procedural or a temporary basis. And we already know there are going to be a bunch of those. We also think it's very, very likely that some of the cases that haven't yet matured into certiorari petitions for the court are going to do so. For example, those National Guard cases involving President Trump, the birthright citizenship cases, those aren't before the court yet. And yet, by the time next year rolls around, very likely, I think, that cases like that will have turned into cases that the court has agreed to hear.
Of course, we'll continue to follow all of this. Walter Olson, Senior Fellow at the Cato Institute, thank you.
Thank you.